I think it forces us to look at ourselves first. So it's easy for me to assume that just because I'm Black, that's why you acted the way you did. But that's the fatal error of attribution. But some people have gotten professional at doing it.
And if I could just tee off that for 1 second,
Go ahead.
that's exactly correct. It becomes a job for them.
Yes.
And sometimes you can demonstrate this from employer to employer, because we'll subpoena the records from prior employers and see what what trouble you got into, at your prior job, or how things went down there. And sometimes you see a pattern, and you have people who, whatever it is that they identify with, that becomes the way that the prism through which they view everything that happens to them in the world.
Welcome to Peter and Phil's Courageous Conversations, a podcast addressing race relations and social issues in hopes that you'll be inspired to do the same. Now, let's begin our conversation with your hosts, Dr. Peter Weinstein and Dr. Philip Nelson.
Good morning, Phil. Good to see you again.
Morning, Peter. How are you this morning?
I am great, and we are joined this morning by a guest. This is new for us. We usually kind of keep the doors locked, the windows closed, and hope that nobody's listening into a bug or something like that. But we are honored this morning to have a guest. I want to welcome Shannon Jenkins from TLD Law as our guest this morning. Welcome, Shannon.
Thank you, Dr. Weinstein. It's such a pleasure to be here with two who I consider to be just intellectual giants.
Wow. He obviously has no idea how tall we are.
Maybe we should just stop right there, because I want to put that on the website.
Welcome, Shannon. We're happy to have you here this morning, and looking forward to a stimulating conversation and to see your perspective on certain issues.
Thank you so much. I have, over the course of the past year and a half or so, had the opportunity to listen into several of the podcasts. And after doing so, reached out to Dr. Weinstein because the content was very interesting to me. And I wasn't hearing a lot. I would guess I would characterize it as more conservative viewpoints on some of the topics that you had covered. So I reached out to Dr. Weinstein and I said, yeah, but have you considered this, and this? And he said, well, that's coming up. So coming up finally came up, and now we're here. The level of dialogue and debate that you two have displayed over the course of the past year and a half is what prompted me to say that I am in the company of intellectual giants. I think that you both make such stellar and excellent points, but maybe there's room for some discussion about maybe a different perspective on some of the things that you've covered.
Well, there's definitely room for a different perspective. There's always room for a different perspective. That's what leads to these courageous conversations. And honestly, I'm glad you're here because we're getting a little bored with each other, and we need that challenge of another conversation. But more importantly, there are only so many ideas that are in these two heads, but that isn't the purpose for these conversations. Our purpose was to stimulate those conversations with people unlike us, and to hopefully model a way of exploring these different conversations in a stimulating, civil way, rather than shouting at each other, and understanding our background. First, can you tell us a little bit about yourself?
Certainly, thank you. I'm an employment lawyer. I work on the management side, which is generally the defense side. So I represent business owners, management, and companies in employment-related disputes, everything from training, kind of some of the more prophylactic actions that a business can take to protect themselves from liability, all the way through to litigation and sometimes appeal. And I've been doing this since 1997. And because of the defense orientation in what I do, I have developed a set of beliefs, positions, and approaches that trend toward the more conservative view, if you will. And so one example of that is what I would call a healthy, sometimes you might refer to it as a robust, other people might refer to it as an unreasonable skepticism of the claims that the plaintiffs, the claimants, generally the employees, make against the businesses that I represent. So I tackle a set of facts with the open-mindedness that's necessary, I think, to balance an understanding of a case, but with a skepticism and then an aggression towards defending the business from those practices. The thread that really got me started and led me to reach out to Dr. Weinstein about some of my thoughts and impressions on what you were discussing involves when a client of mine is faced with a claim that there's been a violation of their rights because they are in what's called a protected class, right? So a lot of the issues that you touch on deal with race issues, and that is a protected class. But there's a whole list of protected classes under California law that we find ourselves in the position of having to defend. And these are all people who claim, and I guess the reason why this conversation is courageous and maybe a little bit controversial is because my nature is to use somewhat charged language like victim. So the putative or the alleged victims will claim membership in some sort of a protected class. Okay, so I hope that you don't take offense at my use of those words. It's second nature to me. And oftentimes when I'm dealing with distressed business owners, they want to know that their lawyer is just as upset about these things as they are, you know. So I will say when a claim is made against an employer and it's one based on the protected classes, you have race being an issue, but you have a whole host of other protected people that claim victim status. Okay, this is my view of the world based on my experience. So we have race, religious creed, color, national origin, ancestry. And again, national origin and ancestry, those are two different protected classes. I challenge you to find somebody who knows the difference or can articulate well the difference between those two.
What two now?
National origin and ancestry.
Ah.
And then you have two like race and color. Okay. In a lot of people's minds, those might be the same thing, but they're not really the same thing. They're two different protected classes. You have physical disability as a protected class, mental disability, medical condition. A medical condition would be something like cancer, AIDS. I mean, it's very specifically statutorily defined. Genetic information, marital status, sex, gender, and gender identity, and gender expression. So those are four separate protected classes. Age, sexual orientation, veteran or military status. And then, of course, the refusal to hire any of those people or taking of adverse action against any of those people or anybody associated with any of those people. Those are all protected classes too. So,
and by the way, I stopped taking notes at physical disability. I couldn't keep up.
Right. So, your conversations, I think, at least the ones that I've been able to tune into, really tackle this very controversial and courageous topic of race. But when I'm dealing with victim status, I'm dealing with a whole host of protected classes under our California statutes. So when we talk about concepts, ideas, ideals, utopian thoughts about how the world should work and should function and how we should interrelate with one another, there is a huge difference in my mind between what occurs in an intellectual debate and what occurs in the real world. Because employers who own small businesses or mid-sized businesses, you don't see it as much in the larger businesses because there's so many administrative layers. Those people are dealing in the real world about what it means to say, I am in a protected class and I have rights. That's where the rubber hits the road from them. So a little bit more about us and our firm. Even though I'm here today speaking to you as a private person and just giving you my opinions and my experience, I don't purport to speak for anybody else in my firm. We are a majority female-owned firm. So 5 of our 8 partners are women. And amongst the 8 of us, we have people of color, we have people who have disabilities, hearing disabilities, people who are of LGBT status. So we are considered a diverse firm. Under the law, we consider ourselves morally and ethically and socially as a diverse firm as well. And we value tremendously the idea and concept of diversity. I think that we can all agree, and Dr. Nelson, you talked about the idea of things that we can all agree to. Okay, we can all agree it is very bad to take an adverse action against somebody based on their membership in a protected class. I don't view that as being controversial. And it's something that we all know morally, ethically, socially, and intellectually that we should not harass people based on their membership in a protected class or take discriminatory actions against them based on their membership in a protected class. Where much of the skepticism, the anger, and the frustration of people is when confronted with a generalized dialogue about people believing they're victims. Where that comes in is when the people in protected classes weaponize that against the business to gain a result. And so I, as the defense lawyer, look at a set of facts and I do what I can because we all carry whatever biases and experiences we have to the table. Look at a set of facts, evaluate it objectively, and determine that this is a fake claim. But it's topical. It may be topical, it may be in the news for whatever reason. You may be an immigrant, you may be of a particular race, and it's the topic of the day. So I look at that and I see what happens when being a member of a protected class gets weaponized against a business. So you might, as a business owner, and this would be a real issue that you would face, you might take some disciplinary action against somebody because they're chronically late. Attendance issues. And if you have somebody on the other side that knows how to play the game, their response to that might be, you're targeting me because of my insert protected class here. You see that as a defensive mechanism all the time. You're targeting me because I'm a woman. You don't treat other women this way. How do you defend yourself from something like that? And so then you see the employee creating a case, right? Because there is unlimited and almost universal access to all of the ways in which you can craft a good employment case available on the internet. It didn't used to be that way.
So Shannon,
yeah,
may I interrupt you
please
for a moment? Do you ever find yourself thinking about being the plaintiff's attorney and the nature of the claims that are legitimate from a plaintiff standpoint that may truly show unlawful action by the defense? Do you ever try to put yourself in somebody else's shoes?
I do. And from time to time, because of a referral relationship or a conflict, I will take a case where it is an employee making a claim, but generally speaking, because of my philosophical nature, it'll be not litigation, but it'll be to negotiate a severance agreement or review a contract, things of that nature.
It's a tough situation when you're asked to put yourself in somebody else's shoes, isn't it?
Well, okay, you're asking that of a lawyer. And this is a job.
Yeah.
And in my job, like for most people in their jobs, you're here to earn a living. Have I abandoned my ethics or my integrity to advance a claim that I didn't believe in? I don't think I've gone that far. But I will say that I've looked at it from my client's point of view.
First of all, that was a fascinating description of your world and the issues that you have to tackle. You used the phrase intellectual debate versus real world, and then you tied it to your profession. So let me start out by saying that I recognize there are bad people that will abuse and use the system. And I don't care to estimate how many of them are out there. It's definitely enough to keep your business going. On the other hand, there are, as you said, some righteously indignant people who have been aggrieved, and you still have to defend the businesses against real charges that in the end you find out that the business was wrong. I'm not sure that our discussions are so ethereal, so intellectual that they don't apply. You also made the comment that those real aggrieved people are the exception, not the rule. That may be in your law practice. I'm not sure I can accept that across the system or in society. And you're being an administrator. I definitely want you for my lawyer because I have the same challenges. You know, you are absolutely right. But what I've seen is people who don't want to be accountable. And so they find ways of deflecting, and litigation using class protection has become a common way of deflecting, of protecting themselves against accountability. If I have to put an employee on leave without pay because they didn't come to work, and this is a step short of dismissal, if that person happens to be a member of any of those protected classes, they could say, well, I know why you did this. I also have to deal with people who find out that another person is making more money than they are and assume or have the self perspective that they are equal to that person, that they provide the same services as that person. And the only reason their salary is different is because of my bias against that protected class.
That's exactly right.
And then they charge me of that bias for discrimination. And in some cases, their information is wrong. They make the same amount of money. It isn't different. But because they got that information, they are now charged. And the reason I'm bringing this up is to say, we recognize that sometimes the remedies are not perfect. The reason there are protected classes is because there was once a rule that provided or allowed a practice that was discriminatory or harmful to a class. And it required recognition, and then it required the law to say you can't do this. But the fact that there is a law doesn't make the law bad. It's the people who use it or abuse it that make it bad. I love the way that you broaden our discussion from race to protected classes, right? Because honestly, all you've done is, well, for me, you've helped me solidify the concept that race and protected classes are concepts. We're human beings and we created these problems. That's why I think we have to have these conversations, because as part of these conversations, I think it forces us to look at ourselves first. So it's easy for me to assume that just because I'm Black, that's why you acted the way you did. But that's the fatal error of attribution. But some people have gotten professional at doing it.
And if I could just tee off that for 1 second.
Go ahead.
That's exactly correct. It becomes a job for them.
Yes.
And sometimes you can demonstrate this from employer to employer, because we'll subpoena the records from prior employers and see what trouble you got into, at your prior job, or how things went down there. And sometimes you see a pattern, and you have people who, whatever it is that they identify with, that becomes the way that the prism through which they view everything that happens to them in the world. So it could be race. I've had those cases before. It could be religious discrimination. I've had, a Jewish employee sue because everything that happened to them was because they were Jewish. You have people who grift off the idea that the law says you can't discriminate against people. So I can make a bunch of trouble for you if I make these claims. Trans claims, same thing. That's a very topical protected class, is people who have gender identity and gender expression, personas that then become the reason why they don't get hired, why they get fired, why they don't get, equal accommodations. So that every interaction with these people becomes because of their immutable characteristics, and it can't possibly be because I'm lacking accountability, as you said. And those are the and it is absolutely true that one bad apple can spoil the entire barrel. And so you get a very vocal, and why I say, doctor, and we may have to agree to disagree on whether or not this is a greater societal issue, or it's more narrow than that, is because you can have one bad apple spoil a barrel, but you have the social equivalent of that is you have a very radical, activist, vocal minority of people that end up driving policy for the entire state or for the entire nation. And out of that comes, yes, there was a time where women demonstrably did not have the same opportunities that men did, and there's still a quantifiable pay gap between men and women. So that is a fact. It does exist, and those laws came into being to prevent, theoretically, those types of things from happening. Those pay equity, gender equity laws, things of that nature. But you can have a very vocal minority driving policy for the majority. That does exist as well.
I hear what you're saying. I do. And putting myself in your shoes and understanding your world, I think I still, and we may have to disagree, but I still stand that this is a societal issue. But that doesn't mean that when the tire hits the road, you're not going to have friction in working this out. And whether they are the minority or not, it's always the vocal minority that tends to change everything.
Yeah.
Right.
True.
It's the vocal minority that creates the friction and forces the change. And so the vocal minority are not the bad ones. It's the ones who have adopted a personal agenda, or who have seen a way to grift the system. But I think there's some vocal minorities who may have been, as you so eloquently put it, they only see the world from their aggrievement. When I moved to California, I saw the world as black and white. I'm from Mississippi, and at the time that I grew up in Mississippi, it was predominantly our social ills were related primarily to black-white race relations. And then I moved to California, and I was a significant minority in Mississippi. 40% of the population, or 30 to 40% of the population, was black. Then I moved to Claremont, and I became an other. There were so few African Americans in Claremont that now I'm a member of the other category. And I suddenly had to adjust to the Asian population and the Hispanic population. I didn't understand how diverse our population was, right? But I still could have been closed-minded. I still could have continued to look at the world from a black and white perspective. And I could have said, I don't care what Armenians have to go through. I don't care what Latinx have to go through. I'm only concerned about Black Lives Matter. I could have chosen to look at the world as every time I have a failure, I need to make sure that it's not because of my race.
How do you do that?
How do I do what?
Make sure that it's not because of your race.
Oh, I don't know how to do that. I don't know how to do that. I'm postulating now. I'm saying I could have done that. I mean, frankly, I think that's a waste of breath to see every interaction from the possible perspective that you care about my race, because that's a social concept. However, let's take redlining, for instance. People who are trapped in certain neighborhoods of certain cities because there was a practice that essentially set boundaries about where they could buy houses or where they could afford. And now we have communities that are in the least desirable parts of the city. And the people who are there because of that historical bias that we were talking about, the historical laws, the rules, not the exception, that sent certain classes of people to certain areas of the city. And now they can't get out easily.
That's where I have to stop you.
Go ahead.
Because then you just added easily.
Yes.
Okay. There is much about many of the circumstances that people face that makes whatever it is that they task themselves with doing not particularly an easy challenge. But that's not to say that it's not impossible with ingenuity, access to opportunity, drive. These are the things that we hire for. Hire you because you are a driven person and you can be driven despite your circumstances.
I totally agree with you. I think where we may differ, and I'm not sure we do, it's just I think that we have a different perspective on numbers. Okay. I think that you may think that those people who are trying to get out of redlined areas, that most of them are whining about their condition and not really trying, or they would rather blame the condition rather than try to get out. And I focus on, I don't care if it's one individual who is trying to get out, but it is more difficult for that individual to buy a house in another neighborhood because there are other limitations on their life that limit their job access, limit their employment opportunities, limit their social opportunities, where they have to be ingenious. They have to come up with ingenuity. They have to be driven, as opposed to people who aren't driven, who may be of a different class, who have no problems buying that house because they had no obstacles that prevented them from employment opportunities or education, etc. And so, again, I am not trying to paint a victim. I am trying to say that there are social obstacles that if those social obstacles make it more difficult for somebody in one neighborhood to change their neighborhood compared to somebody in another neighborhood who wants to change their neighborhood, then there is an inequality that must be addressed.
So actually, I think we are closer than we think.
Yes.
So good to know. So I agree with you that those conditions may exist. I am not prepared to say that they universally exist just because you live in a neighborhood or just because you live in a particular location or have a particular condition. But I am definitely of the mindset that everybody should have equality of opportunity. I think that is even just beyond what I do for a living, as a holistic goal, everybody should have equality of opportunity. That is not to say that we can or should be guaranteeing equality of outcome. That's where individual character, motivation, accountability, all those things come into play. So yes, I think that everybody from the business owner to the mortgage banker should be giving people the same opportunities based on the same set of criteria.
On an intellectual basis, we're definitely on the same page, right? And a lot of that has to do with how we interpret that, or how we equate opportunities, how we interpret equal opportunities can be blurred by our bias and our experiences. And those are differences that are not evil in and of themselves. It's okay that you see it a little differently than I do, because you've had different experiences than I've had. If I may, I'd like to re-ask the question, to ask you to tell us about yourself. And before you say anything, you gave me your professional resume. You told me all about being a lawyer and what you do. And then you dove into our conversation. But I really wanted to know about you. Where were you born? How were you raised? What are your beliefs? Part of our conversations have been, we've started protecting ourselves from each other. And in doing so, we can't share our opinions about each other. You know, I'm so glad you're our first guest, because the more I listen to you, the more I realize you have to deal with both sides of the coin all the time. You are at the crux. I understand why you think these intellectual discussions don't necessarily apply to society. I strongly disagree. I think that if we don't integrate these kind of discussions in our work environment, in our social environment, if we don't start assessing ourselves while we're noting the misbehavior of others, as a society, we're going to fragment even more than we are doing now. So back to you. Tell us about you.
Okay.
Tell us about your upbringing.
This is the uncomfortable part of the conversation, Shannon.
Well, I'll give you all my protected classes. How's that? I am over the age of 40. I am white. I am female. I do not use pronouns. I am married. Marital status is one of those protected classes. Born in 1970 in Loma Linda, California. So I'm a native Californian, and started in 1997 with the practice of law. My parents were what I would call blue collar. Neither of them went to college. A couple of years at Chafee, which they did not complete. That's where my parents met. And my dad was a firefighter with the LA City Fire Department for 40 and a half years. So we lived in Mission Viejo. He commuted to LA City. He commuted to LA City because he didn't want us raised in LA City. That's a whole discussion.
Yeah.
And my mom was a hairdresser, a beautician. So my bias growing up was definitely towards respecting and appreciating and loving firefighters, police officers, the government. I thought the government was a good thing. The government provided for my family, and always very much into rules and following the rules, because there were lots of rules that came along with government and administration. And so I've grown up being a rule follower, love to follow the rules. I have no problem with the rules that business owners have to follow. Some of them are administratively infeasible, but there are the rules nonetheless, and they've been passed by our colleagues, and they're the rules. And so I have no issue with the rules. But because of the way I was raised, I don't like people who abuse the rules. And so there are ideas that when something happens to me as an employee, and I have that victim mentality, I may say that you took this action because of my membership in a protected class. We've talked about that. And that is unfair. So I look at the rules, because I'm a rule follower, because that's how I was raised. And I say, well, the rule says that the conduct has to be unlawful, not unfair. And there's a difference. And so I just came out of a jury trial 2 weeks ago. And the claim was that this gentleman was laid off because he was over the age of 40, well over the age of 40. And that the reason given by the employers was a false reason. It was a pretextual reason, that he was laid off because of his age rather than because of the financial issues that the company was facing at the time. So one of the jury instructions was called the business judgment rule. And the business judgment rule says, in essence, something along these lines, that employment in the state of California is deemed to be at will, that you can be terminated, laid off, let go, action taken against you for any reason, no reason at all, for an unfair reason, for a wrong reason, for a bad reason, so long as it's not for an unlawful reason. And so when I'm defending these employers, I come at it from this perspective. Is what the employee complains of, is it unfair or is it unlawful? And I will tell you that, Dr. Nelson, you talked about us trying to infuse the workplace with broader notions of maybe societal justice. I'm not paraphrasing this correctly, but bringing those greater social constructs into a workplace. And the problem with that, not the idea of it, but the practicality of it is that turns the way that you feel into a gripe about something being unfair. Because it might be unfair when I step out the doors of my workplace, but it's not unlawful. And there's a legal distinction between the two. That's what I get tasked with, cleaning up the difference. Now, what ends up happening is if this case can't be settled because the business owner is scared early on, right, or whatever, if the case hasn't been settled because it's an outrageous demand or there's not enough money to settle or whatever it is, and it actually goes to trial, I will tell you that we have the best system of justice in the world, and it weeds out those claims. I'm not in favor of introducing more protected class issues into the work environment. I will follow the rules, but introducing more of those issues into the work environment creates a situation where more unfairness is being alleged. And then you can have a 2-year case based on unfairness, and then it comes time to prove your case at trial. And what our jury system does is this, and it's the best system in the world. It says, okay, plaintiff, victim, you have a burden of proof. The burden of proof is by a preponderance of the evidence. That is a thing. It's a standard. It's a legal standard. It's the weight of a feather on the scales of justice. Some of your claims have to be proven by clear and convincing evidence. That's beyond a preponderance. That's more than 51%. That's a higher standard. But you have to prove your claims by a preponderance of the evidence. And in order to prove those claims, there's certain elements that have to be met. And let's just say it's a harassment claim, and there's 7 elements that have to be met. See, rules, right? This is how I was raised. You follow the rules. And the rules will tell me if the employer's done something wrong. But boy, you've given us 2 years of trouble to get here, haven't you? Based on your allegations and allegations alone. So when it comes time to enforce the rules, you're facing a set of elements. Let's just say it's a harassment claim. There's 7 of them. And the people that are going to decide this claim are jurors. There's 12 of them, maybe a couple alternates. Those jurors are your community. That's the check and the balance, right? So it's not me as a defense lawyer saying it. It's certainly not the plaintiff's lawyer saying it, but it's the jury of our peers that will make that decision. Those peers come to that jury pool with every bias that you can imagine, hidden or not, every life experience, every protected class that they're members of as well. I mean, that's the check and balance that we have here in our justice system. And so you have to go through the elements, right? You have to prove the things that you say. So you have to prove intent. So you can be out in the world and say, and have a very controversial opinion or try and cram down a very, controversial policy. But when it comes to you actually sitting in that courthouse and asking for money, you have to prove that the actor had discriminatory intent. That is a specific mindset. It's not enough to say, I believe that there is systemic injustice in the world. You have to prove that an actor on that date at that time had a discriminatory intent and made the decision based on that intent, right? Now, there is a different theory, which is discriminatory impact, which means a policy had an impact on a protected set of people, even if the intent wasn't there, but you still have to have statistical proof of that. In other words, evidence of it. So in that way, greater debate doesn't affect what happens when you actually are put to your proof in the courtroom. You have to prove that discriminatory intent. That's one element. Another element is the unwelcomeness of the conduct, right? So here's me, and I'm out in the world, and I'm like, I don't like this, and I don't like that, and boy, you just offended me here, and you offended me there. However, with my friends, I'm pretty loosey-goosey about the language I use, the behavior the way I conduct myself. I may claim that you offended me, but I may engage in some of the very same behaviors myself with a different set of people. So the question then becomes, can I prove as a matter of law by preponderance of the evidence that the conduct that I'm claiming offended me in the workplace is something that I was actually unwelcome to? Or did I invite it? Did I participate in it? And I will tell you that when you get a jury of your peers deciding your fate in the courtroom, they expect you to be better than they themselves are. It's like a thing that our jury consultants warn us about. It's the Snow White complex or the White Knight complex. I forget exactly how it's phrased, but it's like you have to be pure white in terms of how you conduct yourself before you come and ask me for money. So if you've been real casual about the way that you've conducted yourself, that will, you're not going to be able to meet that element.
There's a pun in there. There's a pun in there somewhere, Peter.
Is there? I don't know.
Well, what got my attention is that how come it is Snow White and White Knight and not
That's exactly what I was thinking.
And it's like somehow that seems unfair. Now it's not unlawful, but it's unfair that the terminology seems to have gone.
Literally, but then you could deconstruct everything and make it about like if you are that person that views the world through the prism of race, you're going to pick up on that.
And we do.
But then there's no winning. There's
no. Okay. So
it's not a competition, Shannon.
Yeah. So yeah, exactly.
There's no surviving.
No, Shannon. We actually are having fun with this. I mean, in doing this and trying to make that statement humorous, it doesn't mean that you have a blind spot at all. It was about how society, again, is that bigger issue again. It's about how society views color, period. The White Knight is the savior, as opposed to Zack Snyder's version of Justice League, where everybody dressed in black, instead of the colors you normally see Superman and Wonder Woman in and Batman in. It's the challenge of how we view a white dwarf and a black hole.
Correct me if I'm wrong, because those are now you're getting all sciencey on me because you're a scientist. But isn't whiteness the presence of all color and blackness the absence of all color? Did I get that wrong?
No.
Backwards? I don't know. I'm just saying.
No, I'm only looking at the context in which it was used. But again, we were just having a little fun. I mean, it wasn't. My point was that we shouldn't be judgmental about that.
Agreed. But businesses are bankrupt because people have not been able to, because it's been weaponized.
Or the system has been abused.
Correct.
Right? Winston Churchill said, democracy is the messiest form of government in the world, but it's the best.
So true.
But there's nothing better. And I don't envy you because I think your job concentrates the number of people who try to take advantage of the system.
I think that's very well put. And I suspect you might be right about that.
And so I understand why you are so sensitive. And I don't mean that in a bad way either. I understand why you are so passionate about this. And I also understand that you can't help but be colored by the number of people who seem to take issues that we should be able to solve without going to court. Your interpretation would be either you're just much too sensitive about this, or you're trying to take advantage of the system. It goes right back to the fact that we have people who are trying to avoid accountability, and they're deflecting the real reason they got fired or the real reason they were punished administratively. And we have this we've developed this false sense of pride in whatever our perspective is. I, like you, love the rules. I, like you, well, love is a bit of a stretch for me. But I, like you, respect the rules. I, like you, understand the importance of rules. All right. But I also, and I'm sure you do too, but I probably challenge the rules a little more. I make policy all the time for our college. And I've learned that when we're writing policies and trying to address an issue that is an issue so that we don't end up having to hire you. We're trying to achieve something that, we're trying to make sure that everybody understands this is how this is how we do this, and this is how we're going to handle that, so that as an institution, we don't get in trouble, but every time I do that, I realize that the policy is not perfect. Every time I do that, every time I write a new policy or come up or look at an old one, I either imagine somebody purposefully looking for the holes in the language, or realizing that the language doesn't cover this, or there's something I didn't think about that's going to probably come up, and yet we're going to follow the policy, understanding it's imperfect.
But the problem, yes, and so the problem that you've identified, though, is what every business owner goes through, which is
not just business owner, everybody goes through this.
Well, yes. However, not everybody can be sued for. You know what I'm saying? In other words, again, if you're having an intellectual debate with someone, you may be exposing yourself to holes in the argument. But when you're putting a policy out there that has legal implications, for people that you work with or that you retain or employ, there's a cost component to that where you could suffer some economic damage.
Absolutely.
If you haven't thought of everything. And so and that's the position that they find themselves in. And so why can it not be the case? You can have a law that says you're not supposed to do X, Y, Z. But before you can sue me, right, give me notice of it and the opportunity to fix it. Why can't we have safe harbors?
It fills right into what we're trying to do right here with Courageous Conversations. It's really about communication and conversation within the business place, and not feeling threatened that you can't have that conversation. I think the employee-employer relationship comes with implied threats, and in many cases, the employee is a little reticent to have that conversation, so they let it fester and eventually seek some sort of retribution. It really would be a wonderful situation in a perfect world that people would get together and have these conversations before they fester, before they become big, bad, ugly, and try to remedy the situations well beforehand. And that, I would suggest, that's not only in the business place, but that's in the world.
Thank you for joining us for another Courageous Conversation. Be sure to follow us and check back next week for more.